We're going to talk about a motion to vacate an order of support that was entered upon default. So basically, someone was petitioned for child support. The respondent did not appear in court, and the court went ahead without them and made an order of support. Because we're trying to reopen a case, we are going to use the caption from that case. So the original case was Brian against Lisa. Lisa is our client, and she's the respondent that did not appear. And so she's the one that's bringing this petition to open the support. So ordinarily, her name would be up here as the petitioner. But because we're trying to open a case, we're not trying to do a new case, we use the same caption as the current case. We use the same file number and the same docket number. Where things get reversed is on the family court information sheet. For whatever reason there, the clerk wants um, the person that's bringing this petition to reopen listed as the petitioner. So here, um, even though Lisa is the respondent in the underlying action, she's the person bringing this case to reopen. And so for the clerk's purposes on the personal information sheet, her name goes first. So back down into the petition, again, we're using the same caption. We're putting the petitioner in the original action right here. We're putting in the date of the order that we're trying to reopen right here. And then the respondent is going to sign their name above this line. Then we get into the actual petition itself. So we're going to give both parties names, their addresses, phone numbers, and then we're going to get into the order and what was the excuse for not appearing in court, and is there a defense to the action? Because you could have the best reason or excuse for not appearing in court, but maybe what the court ordered is either what they would have ordered had you appeared, or it could be lower than what they ordered than if you had appeared. So you want to evaluate whether or not it's even worth going in to do this. In this particular case, the excuse was that the respondent's mother passed away the day before court, and she understandably forgot all about the court appearance and didn't realize that she even forgot the date until she received the order in the mail. And her defense to this is that a lot of times when someone does not appear in court, the court will do what's called impute income to them. They will say, okay, well, this person's an able-bodied person of a certain age. They can earn a minimum wage salary for a 40-hour work week. And so when you do current minimum wage for 40 hours of a work week, it works out to like $32,000 a year. And for one child, that works out to about $97 a week in support. So a lot of times on a default, the court will impute income to at least minimum wage. If the other party came into court, the petitioner who's seeking support came into court, let's say with tax returns showing that the respondent in the past has made far more than minimum wage, the court certainly could base an order on that higher number. But without any history or testimony from the petitioner, the court usually starts at the imputing to minimum wage. In our particular case at hand, the defense to the allegation is that this particular client only has SSI as her source of income, that she has a brain injury and cannot work a full-time minimum wage job. So we're asking the court to excuse her for missing that court date and reopening this exact case to reconfigure child support based on the fact that she really cannot work a full-time minimum wage job. If in this case the client missed court and they were imputed income to a minimum wage job, but they come to us and they say, geez, I missed court, now I have this order, and I look at their pay stubs and I see that they're making far more than minimum wage. I will tell them it is not in their best interest to go file to try to reopen this case, because if they do, the court is going to increase the amount of support. They're not going to reopen and get rid of it. So you really want to be careful what you ask for when you are filing something like this. Whenever you do file a petition to reopen a default, you have to provide what's called a financial disclosure affidavit. And so here you'll see the client's going to sign in front of a notary for the petition, and then we're going to get into the financial disclosure. The financial disclosure is really a snapshot of the client's expenses on a monthly basis. The court asks that you attach the last couple of pay stubs that you have, a copy of your W-2 or your tax returns to this financial disclosure affidavit. If clients have at least their pay stubs or proof of Social Security or food stamps or something like that, I will ask them to provide those, and we will make copies and attach it. Sometimes we just do the financial disclosure, and I let the client know that they'll have to bring some of the supporting documentation to their first appearance. So here you're going to see we're just putting in the client's name and their address. And now we're going to get into the income they have from all sources. If they were employed, I would put the employee's name and address here, approximately how much they work, and then I would put their salary. Are they paid weekly, bi-weekly? I don't get into the deductions here because it can change. So I might just put a little note here, see attached pay stubs. And that way the court can look and see exactly what's taken out every week for taxes and other payroll deductions. Here we're listing if there's other members of the household, any dependents, and what the income is of other members of the household. Sometimes the clients know, sometimes they don't. If they don't know, I just put unknown. If they have any self-employment income, we list it here. If they have any interest or dividend income, we list it here. Most of our clients are not going to have interest or dividend income. I would actually say probably all of them do not. Self-employment, maybe if they do odd jobs, and we would put that here. Then we get into other income or benefits. Do they have workers' comp or disability or unemployment benefits, Social Security, veterans benefits, pension, a stipend or supplemental security income? In our case here, our client has the supplemental security income. And SSI is for clients that are disabled that don't have a work history from which to determine a disability payment. If you get SSD, that means you've had a significant amount or a significant enough amount of work history where a disability amount can be calculated. SSI is basically that you really haven't worked enough to have a decent work history. And so they give you, they have a chart based on different things and how they come up with this amount per month. We get into if the client receives public assistance and food stamps. Here we're listing if there's income from any other sources. And that again can be anything that maybe friends or relatives provide. Maybe they have rental property and somebody pays rent to them. We would put that in here. Now that we've done their income, we get into their assets. Do they have savings accounts, checking accounts, a car, a resident, any other real estate? If so, we list it here and the value over here. If they have a driver's license, we list it here and what the state for the license and what the license number is. Lastly, we get into what are some deductions from income. So you can deduct public assistance and food stamps. You can deduct child support if you're paying child support for another child that's not related to this action. And here I just noticed, in addition to the food stamps, I should have put the public assistance in here as well, which is the $500 that we saw here. Then we're going to get into health insurance. Does the client have any health insurance, and where is it through? Is it an employer? Is it private? Is it Medicaid? What does it cover? Do they have any cost that they have to pay? And who does it cover? Is it just the client? Is it the client and family or kids? And then we get into, is there a child care provider and how much expenses are incurred there? Does the child have any educational needs and expenses? And this comes down to when the court's going to figure out of pocket percentages for health insurance or um, daycare expenses or out of pocket medical. They want to have that information here. If the client has any life insurance or accident insurance, we put here. That's very rare with our clients. Then we're going to get into the expenses. And so this is kind of a snapshot of, I typically do it monthly, what their rent is, what utilities are. There's just a laundry list of things here. You ask them these questions, you fill out the amounts, and you get down to what is the total of monthly expenses. The important part with filling out a financial disclosure is that you want the expenses and income to essentially balance each other out. If you put that you're only on SSI for $900 a month, but you list expenses of $3,000 a month, that's going to raise some red flags in the eyes of the court. They're going to want to know, how are you possibly paying for this stuff? Did you not put down all of your income? Um, and then likewise, if make an amount on SSI, but then you have, hardly any expenses, then the court wants to know, well, how are you paying for a place to live? How are you paying for transportation? So again, you want it to make sense for each client's situation. Down here under liabilities, loans, and debts, if the client is paying off a credit card, let's say they owe MasterCard $1,000 and they're paying it, the minimum amount each month, you would put that here. If they were paying National Grid, a large bill and they were paying it per month, we would put that information here. And then finally, the client is going to sign again in front of a notary, and we will make copies of all of this, 3 copies of the petition and the financial disclosure, and the current order that we're trying to reopen, make 3 copies and advise the client to bring it to room 101 to the family court clerk's office for filing. And then they will get notice from the court if they are going to reopen the case, and put it down for another court date. What typically happens is if nobody objects to the reopening, then the court proceeds as if they're starting all over again. However, if somebody does object, let's say the other party comes in and says, her mother didn't pass away, or her mother passed away a year ago, that's a lie. Then the court is probably going to do a hearing or some other evidentiary, want some sort of proof of what the client is saying with regards to why they've missed court. And then if it's determined that there was a valid reason and there is a defense, then the court will start all over again. Again, for something like this, the parties are not entitled to an assigned attorney because it is just a regular child support case. And typically the petition will be mailed to both parties, but I do tell the client to check the summons just to make sure that the clerk did not order them to effectuate personal service.